Hello and welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. Today, we learn the step-by-step process of making a legally valid will in India. Writing a will is a crucial task to ensure your property and assets are distributed according to your wishes after your death. So, let's go through the essential steps and legal requirements to draft a valid will. 1. Use of plain paper. One common misconception is that a will must be written on stamped paper or registered at the time of creation. This is not true. A will can be written on any plain paper, whether it's a blank sheet or a notebook page. It can be either typed, printed, or handwritten by the testator. Both handwritten and typed wills have the same legal validity, as long as other conditions of validity are fulfilled. This flexibility makes it easier for people to prepare a will without incurring unnecessary costs. 2. Key contents of a will. A valid will must contain certain essential information clearly stated to avoid any confusion or disputes later. Here are the key contents your will should include. Full name, age, and address of the testator. This identifies the person making the will and ensures there is no doubt about whose wishes are being recorded. Declaration of sound mind and free will. The will should begin with a clear statement that the testator is of sound mind and is making the will voluntarily, without any pressure or influence from others. Description of property. The will must describe the movable and immovable assets you own. Movable assets: bank accounts, jewelry, vehicles, investments, digital assets, etc. Immovable assets: land, house, commercial property, etc. Giving detailed descriptions helps avoid ambiguity. Beneficiaries and shares. Clearly mention the names of the beneficiaries, people or institutions who will inherit your assets and specify the exact share or portion each person is entitled to receive. Appointment of an executor, optional but recommended. You can appoint a trustworthy person as the executor of your will. The executor is responsible for carrying out your instructions after your death, managing your estate, and ensuring the will is executed as intended. Date and place of writing. Mention the date and place where the will was written. This helps establish the timeline and confirms the will's authenticity. 3. Signature and witnesses. To make the will legally valid, proper signing and witnessing are critical. The testator must sign the will at the end or place their thumb impression if they cannot sign. The signature should be made in the presence of 2 independent witnesses who are present together. The 2 witnesses must also sign the will in the presence of the testator and each other. The witnesses should be competent adults, usually above 18 years, and they should not be beneficiaries of the will to avoid conflicts of interest. This procedure helps prevent forgery and ensures the testator was free and conscious at the time of signing. 4. No need for registration. Unlike many other legal documents, a will does not need to be registered to be legally valid. However, registration adds an extra layer of authenticity and helps prevent disputes or claims of forgery. If you want, you may register the will with the local sub-registrar's office by paying a nominal fee. This is especially advisable if you have significant assets. Registration makes the will publicly known after your death and reduces the chances of family conflicts. 5. Writing in local language. The will can be drafted in any language the testator is comfortable with, be it Hindi, English, Marathi, Tamil, or any other regional language. This ensures the testator fully understands the content of the will without language barriers. If the will is in a regional language, it is advisable to have a certified translation available if the property is outside that region or in case of disputes. Additional tips for a valid will. Make sure the will is clear and unambiguous to avoid confusion among heirs. Keep the will in a safe and secure place and inform a trusted family member or executor about its location. Review and update your will periodically, especially after major life events such as marriage, birth of children, or acquiring new assets. Avoid making multiple wills for the same assets unless clearly specified, as this can create legal complications. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. We have explained the topic of will in 6 parts, so for complete information, do watch the next video. What can be willed? Self-acquired versus ancestral property. I will see you again in the next video. Jai Hind. Jai Bharat.